So we've just left the Constitutional Court on an application by the state, the Attorney General, to remove Mr. Hakainde Hichilema as one of the respondents in the petition. As you are aware, Honorable Brand Mundubire and Mr. Mkandira here, Mr. Celestine Mkandira, had sued Mr. Hichilema and Mr. Hakainde Hichilema, has sued the Attorney General and Mr. Hakainde Hichilema as parties to the matter before court. I will not go into the merits of the issue. So we came for an application wherein Mr. Hichilema wanted to be removed as a party. Unfortunately, the Constitutional Court has agreed that he should be removed as a party from those proceedings. But what's the way forward? The way forward is that we are not convinced that that's a proper position of the law, in the sense that there's a confusion between immunity and personal capacity, and we want the full court. So the instructions we have from the Deputy Secretary General here, who is a petitioner, is that we must approach the full court in order to settle this matter once and for all. A person in the office of the President who breaches the Constitution must answer for the wrongs in their individual capacity. Immunity is different from capacity to answer for the wrongs. And as you are aware, the Zambian Constitution is a copy and paste of the Kenyan Constitution. In Kenya, the Supreme Court of Kenya has ruled on almost 11 cases that we presented before court, and which unfortunately have not been addressed, is that the President, when he sued in a constitutional issue that involves a constitutional breach, the President must answer personally. The Attorney General is a representative of government, is a lawyer, chief advisor, legal advisor of the government. Government is not an individual. As you are aware, from basic civics, government involves 3 arms which are separate, but they complement. This is executive, legislature, and the judiciary. But where there's an allegation of a breach of the Constitution, the President must answer individually and not with the government. So, in a nutshell, the Deputy Secretary General here, who is a petitioner, and of course, both the petitioners, we are not convinced with the ruling of a single judge. We are approaching the full court so that we settle the issue once and for all. Immunity is a separate issue. Capacity is a separate issue. And we are more so convinced in the sense that the 60th Republican President, Mr. Edgar Chagwa, may so rest in peace, he didn't file nomination papers in 2026, but the court ruled in the Michero Chizombe case that he was not eligible in 2021 and is not eligible in 2026. The court on its own said, brought 2026 into the picture, that he was not eligible in 2021, therefore is not eligible in subsequent elections. What that meant is that Mr. Edgar Chagwa, President Edgar Chagwa, may so rest in peace, was not eligible in 2026. According to them, he was not eligible in 2031, he was not eligible all subsequent elections. So, even in this case, we are saying, in that petition, the petitioners are saying, Mr. Hichilema, after being found that if the court will find that he has abrogated the Constitution, it must pronounce that he is not eligible to stand in 2026. So the confusion of Michero Azombe is not us who brought it. We found it. And as we say, you cannot say it benefits this person, it shouldn't benefit this person. So this is the point we are making. So we are approaching the full court to settle these issues. Yes.
So when are you expected to?
Right now, after eating, we are going to work. And remember, we are lawyers, we anticipate certain things. You know, when you go to court, you anticipate either you are going to succeed or you are not going to succeed. So we anticipate. So immediately after eating, we will work. We may file today, we may file tomorrow, but the indisputed fact which the Deputy Secretary General mentioned is that our instructions as lawyers, our instructions are that we must appeal the ruling of the single judge. We approach the full court so that we settle this matter.